All right.
On Pedro, yeah.
We're alive, and I think we have a quorum now. Welcome back, everyone. We'll do some quick administrative updates. Then we'll discuss what we heard this morning from the witnesses, and then we'll hear from Tom about issues we considered at prior meetings, and then finally we'll end with public comment. So first on the administrative matters, we'll begin with approval of the minutes. Will somebody approve the minutes from the May 20,
So moved.
2022 move?
I'll second.
Great. Any opposed? Okay, approved. Those minutes are now official. Thank you. Next, I just want to say a couple words about the three strikes report that was published by CPL this week. This was the report that I mentioned during Professor Raphael's presentation. The report was prepared by the California Policy Lab with data gathered by the committee. The report examines the use of three strikes over time, who was sentenced over the law, and county variation between usage of the law. There's two points that I thought were worth highlighting here, at least. First was perhaps this should not come as a surprise, but the three strikes laws disproportionately applied against people of color, particularly Black defendants, and particularly those facing life sentences under the three strikes law, rather than just the double sentences. And then the second was that using an analysis called with synthetic control analysis, Professor Raphael estimates that there was no impact in improving public safety with implementation of the three strikes law. And finally, up to 1/3 of people incarcerated in California are serving an enhanced sentence as a result of the three strikes law. That's both three strikes and second strikes. So I just wanted to, it's a really exhaustive and thorough report, perhaps the most thorough ever done about three strikes. And I want to thank Professor Raphael and his team for putting it together. This is just the first in a series of reports that CPL and the committee will be putting together to examining California's criminal laws. And I'm very excited to start seeing the fruits of this research. Next, I want to give a quick update about the legislation that's related to the committee that's been either enacted or is awaiting Governor Newsom's signature. First, there were two important budget items that were passed as a result of the committee recommendations. First was a generous funding from the legislator to continue our relationship with California Policy Lab. And I just want to give a special thanks to the governor's team and the Department of Finance and the legislative committee budget members for making this partnership happen. The next, more substantive, this was spearheaded by Senator Skinner, was implementation of a committee recommendation to expand CDCR's residential reentry centers with an infusion of over $100 million. So we think that that's a big, important step forward towards doing reentry work. And of course, Senator Skinner and her team were, instrumental. There's a lot of people we met weekly about it, Tom, Natasha. So thank you all. In addition, there are 5 more bills that we recommended that passed the legislature that are currently awaiting Governor Newsom's signatures. These include expansion of mental health diversion, which is SB 1223, improving alternatives to incarceration, which is AB 2167, and ensuring retroactive application of the Racial Justice Act, which is AB 256. That one in particular comes from a recommendation on elimination of the death penalty. I also want to note that the legislature passed AB 2418, which is really a groundbreaking bill requiring prosecutors to collect and report data. This is something that we've also been working on. This bill will, among other things, create an advisory board with a slot for the chair of the Penal Code Committee. So it's something that's closely connected to our business. It's something that we have been involved with. And then finally, on a similar theme, I want to note that the committees, our data gathering ability was expanded by the legislature with the creation of a new section of the government code that allows us to collect data from local county agencies, which has been an obviously important part of the system and something that's been difficult for us to get, or really from any agency to get. So I'm excited to start collecting information on that as well. My final administrative matter is I wanted to briefly discuss the schedule for the next year. Our next meeting is going to be on October 11 and 12. And we're going to tackle, sort of continue the theme in some ways of today of early intervention in the justice system with a really tricky problem of bail and some other pretrial issues in California. So probably all aware there's been a great deal of legislation and litigation on this issue over the past several years. It's an incredibly complicated thicket on top of a complicated policy matter. And in some ways, I think that it's right, it should be right in our wheelhouse, or at least the mission of the committee, to really be able to spend some time and think about very complicated and important areas of criminal law that are almost too complicated for the legislature or committee to be able to do by itself without our support. So I look forward to it. I know it's a big challenge for us, for staff, for everybody.
Michael, do we have any further dates this year? I'm just looking.
We don't have any dates for certain, Tom. We're going to try to meet in early to / mid-November. Is that right, Tom?
That's
so
right.
We're meeting every month?
Well, that's one way to look at it.
Yeah.
After taking many months off.
Well, okay.
So substantively, the October meeting should be our last substantive meeting.
Right.
Okay.
The following meetings will be meetings to approve the final recommendations and report, which should not be quite, which won't be as long.
Those have historically been very to the point. They won't have witnesses or anything, and maybe be an hour, 90 minutes or something at the most.
Yeah, that's better, because two days back.
No,
is arduous.
We only have one more substantive meeting this year. That's the October 11th and 12th. And then we'll meet again. We don't have an exact date, but we'll get back to you in basically early mid-November to finalize our recommendations. Part of the reason why we're cramming here is because we want to get our report and recommendations to the legislature as early as possible to be as effective as possible for the following legislative cycle.
Okay. Yeah.
Then after that, November
2024 calendar, by the way.
I would say after that November, that short November meeting, I think we probably wouldn't meet again until late January at the earliest. So there'd be a big chunk of time off after that. So that's the plan.
All right. So those are the administrative issues. Are there any administrative questions that I can address or Tom can address? All right. Just brief overview again on the schedule. Substantive meeting on bail, October 10th and 11th, or 11th and 12th, which is it?
11, 12.
11 and 12. Then we will have more administrative meeting after that to approve our recommendations in mid-November, and Tom and staff will be in touch with you to schedule that meeting. And I think Tom is right. It will be less than 2 hours. It should be. So returning to the main business of today, which is discussion and testimony. And our point, the discussion of the testimony we heard this morning. And the goal here for this part of the meeting is to prioritize ideas and proposals for further research and refinement by staff. So we are not now needing to agree on recommendations, merely just to get a little bit, hone in some of our ideas and things that we either want more information about or where we think we might be headed towards. I want to emphasize that we are not voting or formally endorsing any recommendation, but only identifying ideas of interest and what we heard and was contained in the memos and written submission from our witnesses. The goal for staff the goal is that for staff to focus our attention on specific proposals and details and report back to us in our next meetings. As we've done in the past, we'll vote on a final recommendation towards the end of the year. This is what I was just saying. And those recommendations will be published in our annual report, which we intend to get out before Christmas. Is that fair, Tom? Yeah, okay. But again, today, as merely a first step in the process, and we have the two topics, which are traffic stops and appointment of counsel. To cut to the chase, from my perspective, I was on the traffic stops. So let's take traffic stops first. There's the two ideas that popped out to me as to being the most interesting, and was to eliminate, should California eliminate traffic stops for non-moving violations? Or perhaps maybe we should, first step would be even just to define safety related or moving violations from those non-moving violations. And by non-moving violations, I'm talking about like expired tags or tinted windows. That even might even qualify as a safety related one. But the expired tags, I believe from the data, is the most common reason for traffic stop besides speeding. And should we just say the police cannot pull you over for that period? Or should we take there's a different approach which is the LA approach, which would allow for those type of stops, for any reason, but the police officers, they're trying to limit the expansiveness of it by saying that police officers should have some articulable reason why they're pulling you over for a safety reason. I just can't imagine a safety reason why you should be pulled over by a police officer because you have an expired tag. Just like, I think we should just cut that out.
Are there any other jurisdictions in California that have a pilot project similar to LAPD? It would be interesting to see. I read the summaries, and I like the LAPD approach, and I wonder if we could recommend some pilot projects, and then with the goal of phasing out those kinds of stops. I don't know, just a more gradual approach as opposed to saying blanket. You can't stop for a non-moving violation.
Yeah.
Go ahead, Judge Henderson.
No, most of those, broken taillight,
Yeah,
expired license, those aren't really moving violations that
Right.
require police to stop. Maybe some other, expand the meter maids. You park, give them while they're parked. Go
Yeah.
around parking lots and on the street and in driveways. And if you see it, ticket it there or something.
yeah,
I agree that they should be ticketed. I mean, we could, of course, there are plenty of tickets, even for moving violations that are done without police stops, like those red camera lights or running through a toll booth.
Right.
And, I'm not saying that those should be eliminated. I just think to avoid the police encounters.
Mhm.
There really seems to be very little, if any, law enforcement justification for it. I don't think it's in the data that we received, but this is something else that I would love to hear from staff. On particularly the most common non-moving violations, or however we're going to categorize them. What's the ratio? It seems that there's increased racial disparity in those situations as opposed to speeding and running red lights.
Yeah.
And if there's a decreased law enforcement justification, meaning there are fewer hits in those cases. I'd love to know if we can isolate it that far down, because if it's especially racially disparate and especially poor law enforcement, I would be in favor of eliminating. I hear what you're saying, Carlos. I just think that and we should all think about it a little bit more and see how it could be done in legislation. But it seems difficult for us to say police officer should articulate, whereas it's more of a bright line for this violation, you just can't pull somebody over, period. It seems simpler. I understand what you're saying. It's a little bit cold turkey on those issues. And maybe it wouldn't be for all non-moving violations, but for ones like expired tabs, which is like kind of not paying your taxes. I mean, that's like the real reason.
yeah.
And especially if it's a common one, if we can isolate that out, which I think it is the most common one. Those are my thoughts, at least.
Mhm. Well, I like Dalton's idea. I mean, I have kind of a fetish. I just did this yesterday. I saw expired tags, and I don't say anything, but you see them all the time when cars are parked.
Yeah.
Well, the idea of using I mean, I guess meter.
Yeah.
I don't know, meter maids, I don't know what's the
Probably that's a,
term of
Mm.
art.
That's extras.
yeah,
Um,
an unwoke way to say it.
yes, I
Um,
apologize.
Yeah.
But certainly those canons should be enforced, I think. The
Right.
question, I mean, we're trying to deal with is these pretext stops. I don't know if the right word is impressed, but I was glad that the representative from the Los Angeles Police Department
Yeah.
was very candid that these are
Yeah.
pretext stops.
Yeah.
He wasn't saying that we're really concerned about, license registration, and we enforce every law and every law equally. I mean, she was saying that they're pulling people over for other law enforcement reasons.
Right.
And to me, that's very troubling, I think.
Very troubling. And I think it's why it's so racially one-sided. We know they don't do that in Beverly Hills or in Atherton or Burlingame or Palo Alto.
Yeah.
I think that's why it's so one-sided.
And given what a poor law enforcement tool it actually ends up being, it would be one thing. I think we would have a harder time perhaps if they were finding contraband at every stop,
Yeah.
well, that would be something you're really, helping improve public safety. But given the dangers involved to everybody, the harassment, community, I don't think we can eliminate it altogether. I mean, as anybody who drives a car knows that you can almost be pulled over for any reason, didn't stop long enough at a stoplight or going 2 miles over a speed limit. And we won't go, I don't think that we should try to even approach those right now. But I think some of the ones that to me seem quite obviously not safety related. Well, first of all, I'd be curious about other jurisdictions, Tom. I'd be curious about what the data show in California with respect specifically to the non-safety related stops, about racial disparities and public, we'll say law enforcement success rates or hit rates or however you want to describe it.
Yeah. Yeah. I agree, because I don't think LAPD is the only one that has this kind of modified policy. I mean, I think their time is better spent, really doing other things as opposed to using a traffic violation as an investigative tool. We used to call those Hummers. It's like,
Hummers?
Yeah, Hummers.
Ah,
In terms of the probable cause for the stop. But under that Wren case, any kind of little traffic violation should be the basis, to stop somebody.
yeah.
But it's just a tool, and it's disproportionately applied to, as on a matter of a hunch, basically.
Yeah.
And not a good tool at that.
Yeah, but I've been living in LA. I've noticed that, I mean, people commit U-turns and other violations. It's like they kind of sense that the police are not going to stop you for minor traffic violations already. But there's always that exceptional case. But the ones I see the most are, they run the plates and it turns out to be a stolen vehicle, and then there's a pursuit. So.
And they could, run your plates too if you've an expired tag. I mean, there could be ways of,
Yeah.
searching for warrants.
Yeah.
I'm sorry, I lost my train of thought. Well,
Can I just jump in here real quick?
of course.
I haven't had a lot to say today, but I thought one of the more interesting topics was the idea of the expansive use of consent searches,
Yeah.
and how there should be a requirement that the officer be able to state a reasonable suspicion before asking for consent to search.
Mhm.
And even the more radical notion that they have to get a supervisor's permission to ask for consent to search a vehicle. I don't know how we address that. Maybe it's too big a bite, but I found that fascinating, because what they said was that if you have that requirement of a reasonable suspicion or a supervisor's authority to ask for consent, it reduces the number of searches. and it impacts in a positive way the racial disparities. So I don't know if anybody can think of a way to address that through legislation, but I found that fascinating.
Yeah, my take on that, Peter, was, to get permission from the supervisor, that's only going to prolong the detention,
Yeah,
you know?
but it may discourage officers from stopping and conducting unnecessary searches because somebody has a broken taillight. I don't know.
Yeah,
I mean, I think you could, I found that very interesting as well. I think, you could say that somebody has to be a rank of X official to approve a search, right? That's how you could legislate it. I think that that's difficult. I sort of liked the idea that, again, LAPD is spearheading. I want to hear the results about the Mirandizing people
Mhm.
before the search. Although, of course, as we discussed, plenty of people confess after being Mirandized.
Yeah.
So, did anybody? Is there? I share the suspicion that getting a supervisor is practicable.
Yeah, right, exactly.
But is there another way? And I'm not sure that just maybe stating it out loud as here's my suspicion, here's my reasonable suspicion. And they can almost search a car if they have reasonable suspicion. I don't understand how a statute would really work like that. Tom,
Yeah.
do you want to jump in?
It becomes angels on the head of a pin territory a little bit. What's less than reasonable suspicion, but more than an impermissible hunch. Some states do divide up those categories finer and finer. But I think it's a little difficult to come up with examples where you don't have reasonable suspicion, but you have something that would sort of justify a search. But I think some places are able to do it and it happens.
So just to clarify, because if a police officer has reasonable suspicion, they can search your car. Now, not the whole car, but they can.
It's called a car pat down, which doesn't really make sense as a metaphor, but the idea is you can do a search for weapons or specific pieces of contraband that you have some reason to think are in a particular place in the car, I think. So you can't go open the trunk, take everything out, the whole thing you sometimes see, but you can certainly do a minimal search.
But you can search the whole car if you have probable cause.
Yes,
Right.
right.
So consents are a huge problem, Peter.
I mean,
go ahead.
Another way to look at it is, there's a big number. The rate. This is in the memo a little bit. I think there are bigger racial disparities in consent searches done for traffic violations that aren't a public safety risk. That might be one way. If you really want to look at, someone who's pulled over for a non-safety related reason and talk about consent searches in that area, that might be fruitful, because there's some evidence that the RIPA board found that's where a lot of the pretext stops are happening.
Wouldn't our proposal idea to limit or eliminate those stops altogether solve that problem?
Yeah, it would. So if we're in sort of the universe where that has happened, if we want to think about one where there isn't, but tying it to the underlying offense might help a little bit. I mean, you could do it almost for any traffic stop. If just because you're speeding, there's no reason to think, you're going to have a firearm or something else necessarily. So I don't know how helpful that ended up being.
Well, I think for purposes of today's discussion, I think we're interested in in two parallel ideas: ways to limit or eliminate or stops for non-traffic related. And I even think getting language for that, because we keep on saying non-traffic related, non-safety related, or moving violation, or whatever. Maybe even defining those would be helpful, not just for our purposes, but I'm just in statute even.
Yeah.
But so that's number one. And then number two is, what would be an effective way to limit the racial disparities in particular in consent searches? Is it the Mirandizing idea? Is it stating a articulable reason into a recording? Is it telling the suspect that reason? Are there ways to do it, and have they been successful anyway?
Mhm.
Are there any other areas that folks are curious about or want further research on?
Yeah, the only thing I would add, I'd be interested in what the case law is on this.
Yeah, we could do that. I agree that would be helpful, both the federal and if the state.
Well,
case law
California law, because I
Yeah.
remember having a case, I forget, the officers would use as an investigative tool, one of the questions was, are you on probation or parole? And they would use that as a wedge to do a further search, and that's impermissible if they're basically just fishing. And it's not really a probationary supervisory search. And you can find the case somewhere. But I would be interested in that kind of research for these, ruses where they use that kind of thing or something else to create the, rational suspicion leading to probable cause. I mean, they're very innovative. So I think that would help. And the other thing, as I said at the beginning, I wonder if we do need a statutory change, or is it one policy like LAPD that, maybe the remedy is already before us in terms of policy changes as opposed to statutory changes.
Well,
Yeah, the other thing I think that was very telling is the difference in approach. Highway patrol versus local enforcement.
Yeah.
It's clear that, the CHP is staying in their lane,
Mhm.
but the police are really using, these technicalities, so to speak, to really engage in further law enforcement purposes. So that's very telling.
I thought so too. Well, LAPD, I forget her name, but the representative from the LAPD, she did offer to share our data, and perhaps by the time we meet in November.
Rhodes, was that Rhodes?
Yes, Ms. Rhodes.
Rhodes.
Liz Rhodes. Perhaps we'll have, even if it's just preliminary information on how successful their interventions have been. Because I agree that we want a more limited intervention, but if it's not very effective, then
Right.
it's not super helpful.
One further thought, and I don't know if this adds anything, but I think it gives a little more insight into this process. I still go down to LA in the hood and 43rd and Central and in that area. And if I drive through there in my little modest gray Acura, dressed the way I'm dressed, I think there's 100% chance they're not gonna presume and say, whoops. But but in going back there still, I can tell the players, the pimps and the drug dealers, they drive a different kind of car and they look a little, and those are the cars there's no scientific evidence on this, but I know it and the boys down there know it. Those are the people they're pretending to stop and trying to see what they have in their car. I don't know how that adds to this and the language, but I think it adds to an understanding of what the police, a lot of what they're doing.
Yeah, I don't know how to look into that. I was thinking a little bit. I was thinking a little bit during the presentation, I wonder if any of this information is broken down by zip code. Tom, do you know if that's a question? Because that doesn't quite get to what you're saying, Judge Henderson, but LAPD obviously covers a lot of zip codes, and there are some zip codes that are, anyway. So, Tom.
I thought I saw something broken down by race, gender, and
Yeah,
age,
there was, yeah,
and then time of day, or night.
yeah.
Yeah, the local, I think the local police department data has zip codes and sometimes even has GPS coordinates, but
Yeah.
the RIPA data reported to the state doesn't have that. So you have to go to sort of the local police departments. And there's been some analysis. I think Chauncey Smith has done some of that, looking at different neighborhoods and how stops are conducted there. But I think one thing on this point is sort of, this is where the hit rates on the searches come in, that they're still so very low. Even I think that was one of the things that those graphs that Steve presented from PPIC showed. Even if you control for sort of
Yeah.
age and all this stuff, you still see these disparities. So I think there is some attempt to do that, and you still see some problematic results.
Yeah,
You know what I would really appreciate is, I know that the law enforcement folks couldn't make it today, but perhaps we could get a written submission or written reaction to some of these proposals from the Police Chiefs Association. And see what they have to say, because the hit rates are so low. Like, what they have to have some law enforcement response and justification. I'm sure it's sincere. But I'd like to hear that side of the story too.
Yeah.
Yeah.
All right. So again, to reiterate on the traffic stops, first, is there a way to think about differentiating between safety stops and non-safety stops? And second, how to deal with consent searches.
Got it.
Joy, did you have something you want to add? All right.
No, I didn't.
Okay. Anything else on this topic for the time being?
No.
Moving to appointment of counsel. I was particularly impressed with the presentation, that this seemed again to be in the heartland of what we want to get to. Reforms that improve outcomes for public safety, improve outcomes for criminal defendants, and reduce racial disparities. And that seemed to be early as possible representation. And I will reserve the idea of representation as by whom, public, attorney or social worker, as early as possible in the process. My understanding of the law, Tom, maybe you could jump in with a quick summary, is right now California law requires, with maybe more than some exceptions, but appointment, arraignment within 48 hours. And then when does representation kick in, Tom?
After that. So I mean, I think a lot of jurisdictions, there's a lot of variation, but as far as what is in the penal code, you're informed of your right to an attorney at the arraignment, but you're not necessarily given counsel for the arraignment. So it might be your next court appearance where you have a lawyer.
yeah. I don't think, correct me if I'm wrong, I don't think you're not arraigned within 48 hours. You have you have a probable cause determination by a magistrate judge. That's the Riverside versus McLaughlin case she was referring to.
Yes, there's sort of, these 3 or 4 things that need to happen. And, the Riverside thing is from the Fourth Amendment, which actually isn't in California law. I think we might look
Yeah.
at that next month. But the actual arraignment rule is, it's promptly, but no more than 48 hours, excluding Sundays and holidays. So, if we were all arrested today, it might be Tuesday or Wednesday before we went to court, for
And
example.
that's if you're in custody too, right?
That's right. Yeah.
Yeah, because I know judges, and Peter remembers this, and they would be on call. I mean, there'd be an on-call judge over the weekend, and you'd get a phone, and the officer would call you and say, these are the facts. And so you say, there's a probable cause to keep this person in custody anyway.
Right.
And we were actually assigned dates on the weekend to go
Yeah.
to a location and sit and wait for officers to bring us PCDs.
Yeah.
And we'd go through them by the ton,
Yeah.
on a Sunday afternoon.
Yeah,
You go to a public office at a public building rather than they come to
Yeah.
your home?
yeah,
For me, when I was sitting in Norwalk, I used to go to the Norwalk substation of the sheriff's department. They had little desks for me. And then law enforcement agencies from within the Southeast District and outside would come and bring their PCDs. And I think it was about a 3-hour affair, and it was pretty robust
Yeah.
business.
Hmm.
when I was in Compton, we had on-call by phone, and they had the phone number. It would be Saturday and Sunday. You were on the duty judge for that weekend, every 3 months
Yeah.
or so.
So
I think-
the place where this gets tricky is that there's two 48-hour rules. There's the Riverside one, which doesn't exclude weekends or holidays, but the arraignment one in Penal Code 825 does exclude Sundays and holidays. So I think a lot of times they're combined, but as you all are describing, they don't necessarily have to be, because the defendant doesn't have to be present, or their counsel doesn't need to be present for the probable cause determination. So some places do it all at the same time.
So, I think a pretty clean proposal would be that counsel needs to be appointed prior to arraignment, with being 48 hours being the arraignment deadline, excluding weekends and holidays.
Mhm.
Whether it's by public defender, or if the social worker goes in, or I don't know if it's wise to legislate. Perhaps we could work on a budget item with Senator Skinner to do some pilots about funding social workers to do some of this work, because that was obviously so successful in Philadelphia.
Yeah.
But I think you should be represented at your arraignment.
Well, but in large counties where there's a public defender, isn't that already the case? I mean, an announcement is made that the public defender is talking to people in the morning before the actual arraignment, at least in my experience. And it's a lawyer who's doing it. I mean, lawyer could use some assistance in terms of interview. So maybe, yeah, something like what you're proposing to fund, that kind of position to assist the public defender really to get that information. But in my experience, very few people opted out. Well, a few people would say, well, I want to get my own lawyer, private lawyer, and continue the arraignment. But the public defender would handle 90% of the cases.
Well, that's an empirical question. So Tom, do we know that? What percentage of defendants have opportunity to have a public defender at their arraignment?
I don't know anything specific, and I think as Galit was saying, there aren't going to be records about that, but I think everyone's experience is, 90% is probably pretty accurate.
Well, wait, that 90% of people get an attorney at arraignment already?
No, I thought you meant who end up
No.
getting a public defender.
No, I'm saying, so,
Well, so it's this question of, do you consider the meet and greet arraignment where you have 5 minutes?
Yeah.
Is that the same as like what Carly Ware described in Santa Clara, where you have days?
let's start with that meet and greet.
Yeah,
What percentage of defendants in California get at least that?
that's going to be very hard to figure out. But what we found is that places that even do that, it's considered pretty cutting edge in California, and other places, as we saw today, it wouldn't be. So I don't think there's lots of, we can't get a number, I'd suspect, but if we did, it would be shockingly low. Let me put it that way.
So
it is a perfunctory meeting, like you're characterizing as a meet and greet, and they get basic contact facts, but then maybe they make an appointment
Right.
to talk to that lawyer, the following week before the pretrial conference. It is kind of haphazard, and it's not like having a private attorney where you would meet with that attorney before the arraignment and go in there fully prepared.
well, I think that's precisely the point. If any of us got arrested, our first call would be his attorney, and before we showed up in court,
Yeah.
God, we would certainly have an attorney standing right by our side. And again, it appears, at least from the data, that this is not only due process right and we all would want it for ourselves, but it's actually a public safety benefit. I mean, that's, I think, the sort of the surprising results in terms of people showing up for court, for not violating the terms of their bail, in particular stay away orders. Who was it that mentioned the stay away orders, which would seem like a particularly important
Right.
rule to abide by, and long-term recidivism. That was, I think, in some ways the most surprising piece. Now, again, this was the robust pre-trial social worker intervention. Do we have evidence that even just that less of an intervention is also beneficial, Tom?
I think so. I think Professor Heaton's submission was basically 3 pages of studies showing similar effects from different places. So if it's not there, he can point us in that direction.
So just to clarify again, even the meet and greet, even if that was all that we required, and obviously counties could provide more, you think that that would be a significant change in California, or do you think that that's already going on in California?
That would be significant, I believe. And that's where some of the, a lot of counties don't have, I think it's around 20, don't have a full-time public defender office. So I think, and, we heard some of the stories, and they were in some of the submissions, particularly from the ACLU one, just about the big, groups of people being read waivers of rights and then pleading guilty that day without speaking to a lawyer. So, it's a significant issue, even if some of the bigger counties are able to do a better job.
Well, right. Although the number of counties without public defenders is a little misleading because they're generally from smaller counties. So it's
right.
Though
not, San Mateo, I mean, not necessarily, but
I know, but
that's probably true if we look at the median size. Yeah.
Yeah. No, I think Kings County is probably the biggest county without any sort of public defender service. Anyhow, I would like further research and refinement of the idea of when statutorily should California require appointment of counsel. Like we've heard, as early as possible and promptly, and I'm not confident that those are good terms. I know that sometimes if you were to say within 48 hours or before arraignment, then you get it 30 seconds before your arraignment, and that you're creating a floor, not a ceiling. But right now, if we don't have it at all, my inclination at this point is to have a fairly hard deadline as to when you would receive counsel. I know that Galit Lipa suggested counsel at 24 hours and arraignment at 48 hours.
That was going to be my suggestion, that if we're going to set a hard deadline, it should be within 24 hours of booking, that counsel be appointed.
I would also be in favor of a statutory presumption that at that point, everybody gets a public defender. That doesn't seem unreasonable to me. And goes along with it, some minimal information sharing. Who's in custody for what?
Yeah. And we also have to consider the costs. And are the county's public defender going to be reimbursed by the state? And then, there's also an obligation by the defendant, if they qualify, if they have the means rather, to pay for part of that. So we can make these orders, but there's also a significant cost associated with it. I do like the Santa Clara system where they cooperate with the other justice partners and they get who's in custody ahead of time. They know when the arraignment date is, so the public defender there has a heads up as to how many cases they're going to have on a certain day, and maybe make some effort to speak to those individuals before they actually appear in court. So, I mean, more is better, but with more is better comes associated costs.
Sure.
Yeah.
And again, as Galit mentioned, right now 100% of these costs is being borne by the counties.
Yeah.
Counties don't like mandates from the state on this, but perhaps there should be some state mandates on this, and then perhaps also some funding or pilot funding to
Yeah.
support some of this. And you could imagine different levels of state funding support, whether it's the full meal deal with the social workers and, you know,
Mhm.
immediately upon arrest, or if it's some more limited support. But it is striking that you can be arrested, held in custody for 48 hours, have bail set, and then been asked to, if you want to plead guilty, all without seeing a lawyer in California.
Yeah.
And it hurts public safety. Right? We're kind of like miss that piece. I mean, right? It appears that this system that we have now actually worsens public safety outcomes.
And it's probably more expensive too, you know, when you add up all the costs, which I know we're not allowed to do, but if you look at the whole system.
Well,
One personal anecdote,
mhm.
when I was a student at Stanford, I think Judge Henderson was probably, you know, the assistant dean there. I externed at the Santa Clara Public Defender's Office, and I basically attached myself to one of the deputy public defenders. These were out of custody though, and I did what Michael, you suggested. As an extern, law student extern, I would interview and get a lot of the factual background and some of the facts for the attorney that I was aligned with. So I wouldn't discount their limitations, but I wouldn't discount, you know, law student externs doing
Yeah.
kind of interviewing that I think someone said, well, we don't really want to get into that. But it happens. And I really learned a lot myself in assisting a deputy public defender and learning the mechanics of an arraignment
Yeah.
appearance and also pretrial appearance.
And the students do a good job. They're really committed to it.
Yeah.
And, you know, if you have someone at the school, like I was there to give advice
Yeah.
to them and guide them through it, they do good work.
They do. As somebody who works with students on cases all the time, I will say that. Well, as promised, I will connect with Mike Wald,
Yeah.
who you worked with on this.
Mhm.
On behalf of Stanford, although of course I'm not authorized to say so, that an imposition, just like the public defenders would say, like, hey, you know, great idea, but you know, you need to support it. So
Yeah.
I'm sure all the law schools would also feel the same way, which would be like, we're happy to provide the service. However, we need funding to support it. So
Yeah.
I don't think it's any more of a solution. And by the same token, there are plenty of social work schools that where, you know, the same story might happen where, you know, social work people in
Yeah.
training. My sense is to scale to the size of the state or even a county, the size, you know, a substantial county, that students couldn't do it all, or even close to it. But can certainly be part of the system, be helpful, improve the legal education, perhaps social work education as well. So I'd be in favor of professionalizing it, but there's no reason why it can't be part of the solution as well.
Yeah. Yeah.
But we can look into that too, Tom.
Yeah, we need many shifts. And I know when we were looking at the competency to stand trial stuff in Los Angeles, I think the one reason they're able to do evaluations quickly is because they have a sort of similar relationship with one of the forensic psychology programs there. So, right, scale, you know, students don't necessarily work on weekends or in the summer. So there's a scale issue, but, you know, it's a big problem. So all hands on deck for sure.
Well, it's a good thing that we're putting a lot of things in the funding bucket when Senator Skinner isn't here. So, you know,
That's why she
Right.
needs to come.
Yeah.
Shut it down.
that'll serve her right for not coming if
Yeah.
Bree or Jess or anybody's in the audience. But is there anything more to talk about on the appointment of counsel issue, or do you think are we refining close enough, Tom, to be useful?
Yeah, I think so. I mean, I think the timing thing is very tricky. And, you know, it might also become something that because all these timing rules kind of work together. You know, there's the probable cause determination when counsel is appointed, how quickly bail has to be set. And maybe when we talk about pretrial issues again next month, some of these things might kind of work together. We might want a more comprehensive approach to the timing, which, in a few weeks we'll have the opportunity to do.
That makes a lot of sense to me.
Yeah. This is a complete aside, and I apologize for it, but did anyone here know Carly Ware before she appeared here? Do you know?
I did not, no.
The reason I ask is that I very strongly suspect she's Jim Ware's daughter,
Oh,
who also was
Yeah.
at Stanford during your time, Carlos, and whom I met it, and I haven't seen her since she was a little girl. But anyway,
small world,
I
yeah.
almost asked her, but I didn't want to embarrass her. So anyway, sorry about that.
We'll follow up. We'll add that to the staff research.
Well, that'll be easy.
All right, unless anybody else has anything on the appointment of counsel.
No.
Tom segued us well, and I'm going to pass it over to him in a second. We want to follow up on our conversation. Now, this is a couple months ago on from our last hearing about competency to stand trial. And as you might recall, we had this kind of conversation following that hearing. And I know that staff, Tom and Joy, and I also should have mentioned, let me just pause here for a second, that Rick Owen, our other staff attorney, is not with us here today because he's on paternity leave. He just had a baby, so congratulations, Rick, or his wife just had a baby, I should say. So baby boy. So congratulations, Rick. I hope you're not watching, but if you are, congratulations. Anyhow, so we sort of brainstorm a couple of solutions to the issue of competency to stand trial. I know that Tom has a presentation for us to further discuss. So Tom, why don't you take it away?
Yeah, sure. So Joy has really been the one leading our work on this, but I get to do the PowerPoint. So she'll chime in. So feel free to ask questions as we go. So there's 4 proposals. 3 are right around the competency issue, and then 1 is sort of about frequent utilizers. So we'll do the 3 competency ones first. And 1 is a bigger proposal, and 2 are smaller. So sort of the hardest thing is first. So, and these are all, of course, in the memo that we distributed last week. So the first one gets to the whole issue of when should we even try to restore people to competency to stand trial after court has determined someone is incompetent. So under current law, as you all know, if someone's found incompetent, they go to the state hospital or they're in the custody of the state hospital for restoration one way or the other. The court doesn't have an opportunity to say, well, does that even make sense for this particular case? Given all the issues we know of the competency process, the expense, the amount of time it'll cost, and the fact that the goal is not to have any long-term solution for mental health issues, does it make sense for this case? And this is sort of what we've done with misdemeanor cases, thanks to a bill last year, SB 317. Beginning this year, people who have misdemeanor charges are not going to be restored to competency. So the idea is, can we take sort of a similar approach in the felony context? And instead of it being automatic, like it is with misdemeanors, we would just have the judge make that decision with our favorite catchphrase, which is in the interest of justice. Should restoration happen here? And if restoration shouldn't happen, the defendant should be, set up with some other intervention, mental health diversion, perhaps a conservatorship or assisted outpatient treatment, basically using all the rest of the structures we have in court for folks in these situations. I won't rehash all the statistics, but, we saw that the vast majority of people who come back after being restored to competency get either time served, dismissed, or a relatively short jail or probation sentence.
Right. Will you just remind us on that? It was like 90%, wasn't it?
I don't think it was that high. I think it was 70-ish percent.
Okay.
And I will say we are actually trying to get more detailed data on that to really dive into it a little bit more. But it was the majority, and I think a substantial majority did not even get a prison sentence at the end of the day.
It was less than a quarter that went on to state prison.
Yes, exactly. And it's tremendously expensive, and there's litigation, all those reasons for a process that even Dr. Warburton said is not really geared towards long-term treatment for somebody. So that's sort of the quick overview. It would be building on what SB 317 did, and would just ask this fundamental question: should we even send this person back for restoration? So some of the things on this slide are some of the things that the court could determine in making that interest of justice decision are, was there a weapon involved? Was there injury? How serious was it? Is the defendant likely to face incarceration if we go through this process and they come back? How long that would be? And of course, anything else that was appropriate. So, of course, we can add to that list or take things off, whatever you all think is appropriate. And I think the other key part of this, as far as just making this sort of the question that would be asked in all felony cases, with some exceptions, there'd be a presumption that we're not going to do restoration for this group of cases here, which is the wobbler offenses, which Justice Moreno goes to your question about the criminal threats cases. So those would be covered. The 1170H felonies, which is the shorthand for those that aren't eligible for a prison sentence, could only get a jail sentence. And then we would also include assault and robbery offenses here, because as we saw from the data, those are among the most common offenses for people who are sent to the state hospital. But we also know that there's just a wide range of conduct that could be covered in an assault or a robbery case, particularly, I think, with this group of folks who have serious mental health issues, as Judge Espinoza has told us a few times. So that the structure would be, if it's a felony, with the exceptions of murder and sex offenses, all the things that are excluded under the mental health diversion law. If the court determines this person's incompetent, the court then has to say, okay, so what are we going to do next, and not just default to restoration. And there'd be a presumption against restoration for those category of offenses there. So that's the proposal in a nutshell, maybe a big nutshell, but yeah.
I have a couple of questions. First of all, this is just a technical question. Do you get credit for time served during your competency restoration?
Yes.
Okay. Because that
Well,
goes to,
Well,
me,
you don't get conduct credits when you're in state hospital.
no,
right.
I understand you don't get conduct credits, but just the straight
You do
time
get your-
you do get. So
You get day for, that's my understanding.
is that right, John?
I think 317 also changed that rule. So I think you do get credit, but let me, I just want to 1000% confirm that. Something I should know the answer to.
Okay, well, that would certainly inform the 1D,
Mhm.
right? The other is I would add to the presumptions. I would say any nonviolent felony in addition. So that would, the primary one there would be residential burglary. Just think if you don't hurt somebody, should be presumed to be.
Sure.
I have one question, Tom, and that is, kind of looking at it in your supplemental report. When the judge concludes that he doesn't need to send the defendant, out for further evaluation, does the judge have some kind of a psychiatric report or probation report, his history of psychiatric issues, without, before making any kind of decision to basically handle this in the way that the misdemeanors are handled?
Yeah, I think, the court would have the evaluation of the alienness of the person who does the competency evaluation.
Okay.
Which I think would cover that. And I think that could certainly,
Right.
We may want to expand what has to be in that report a little bit for this
Right.
to have more
Right,
information.
I would expand in that. I mean, I'm sure it's difficult to predict, but likelihood of restoration, if we're asking the judge to make that determination.
Right. Yeah.
we
Right.
Would want a
Okay.
mental health expert to opine on that.
Yeah.
Well, and I will say there was a bill that I think didn't make it through this year that would have required, as part of the competency determination by the mental health evaluator, to also opine on the suitability for diversion. So there's certainly, that idea is out there that, if we're going to be doing this, we should have a couple of things determined as part of it. All right, well, I'll assume, unless there's any other questions, we'll just sort of, work this up, a little bit further along, we'll do the non-violent offenses, expand that from the 1170H offenses, and I'll confirm on the credit issue. Okay.
Right.
Cool. All right, number 2. So this is the one you just mentioned, Mike, requiring judges to determine whether someone is unlikely to be restored to competency. So there is a a small but persistent group of the competency population that are just not restored. I think it's about 10% of the people who are sent for restoration. These are folks who just have, you know, they might have dementia or other disorders that medication and other treatment just are not going to make someone be able to be competent. So it's not a huge group of people, but you know, I think it's still a problem worth thinking about. So the idea is that the court, with the assistance of the evaluator, should have to determine whether there's a substantial likelihood the person would be restored. And if they aren't, instead of going through sort of the charade of restoration, you're able to just move on to the next step at that time. And I think the other thing worth noting here is a number of states have this as part of their law. I think we got up to around 6, and I think we stopped counting because that seemed like a sufficient number to show that this, common sense idea that other places are doing. So, it has those 2 components, the court decision, and then just, making sure that there's sufficient information from the mental health evaluator for the court to make a decision about it. So again, pretty straightforward, but perhaps there's some questions or thoughts.
We think that this 10% of cases are not restored. Is that right, Joy?
Yes, I think that's right.
And so
We're
some
sort of in that
subset
data we're requesting from DSH. We're hopefully going to get a better breakdown of that as well.
So a judge couldn't predict all of that, but some subset of that would be obvious enough that a judge could guess.
Yeah, I think right. Most of it is probably pretty predictable from what we've seen. And I think, and some judges will not do it, but there isn't a clear, statutory path for it. So it probably limits the circumstances where it should happen. All right, great. Let's keep moving. Number 3, similarly, we're talking a lot about the mental health evaluators. So number 3 is setting a 30-day timeline for that report to come back to the court. So right now there is no deadline. There's no deadlines for almost any part of the competency process, and we've seen there big delays in getting people to state hospital. So the idea here is just to set a 30-day deadline for the report to come back to court, and this is based on what most other states do, I think. And there was also a survey done by the Judicial Council in California showing that 4 weeks is about the average time for these reports to come back. But there is a big range. I think it would range from like 1 to 12 weeks or something like that. So there are some extreme outliers out there. And I know when we spoke about this in May, there's a lot of discussion about, well, what's the point of these timelines? Are they just sort of, we're setting up rules to be broken? Are they actually going to make a difference? And when we were thinking about this more on the staff side, we thought this one made sense because it's at the start of the process. It's something that would just take, getting more evaluators, which is no small task, but it doesn't require, building more hospital beds or things like that. And because now we're sort of asking the evaluator to do so many things to talk about, diversion perhaps, and the likelihood of restoration, it makes sense to sort of prioritize this as something that should happen by date certain. And hopefully, for a lot of the state wouldn't, upset the apple cart too much. So this slide is a little superfluous here, just restates what was on the first one.
I agree that deadlines without teeth are kind of pointless, but why not say that the case should be dismissed if this deadline isn't met? It could be refiled, but yeah,
and that's one way to go. I sort of worry about then, we probably have someone who has at least the seriousness of a mental health issue to have a competency evaluation ordered, and might be an opportunity to try to have some kind of helpful intervention. But if the person's just waiting in jail anyway for the report, that's not really happening anyway, once you get beyond 30 days. So no, I think we could try to incorporate that. It's strong medicine, but if folks are interested in that, we can make that part of it.
A less strong medicine would be that somebody needs to go to court to apply for an extension. The court needs to say, you get an extension.
Yeah.
I think there are some states that do set the deadline, and then they require somebody to come to court to demonstrate good cause for the extension, or something like that.
Yeah, that sounds good.
And then there's a time limit to the extension that they might get. I think like And maybe it's Massachusetts or some state, like then you get an additional 7 days or something, so that then there's at least some oversight of how long it might take until they get the report.
Right, of course, if the judge was able to grant an extension, they should have a time limit on that extension and then come back again. I don't know what we want, the timelines I don't care so much about, but I do think a judge shouldn't just say, yes, it's extended period and with open end.
Right.
The deadline is hereby waived, right?
Yeah.
And there might be, I mean, we don't know, there could be extenuating circumstances that might bump it down for, a certain amount of time, but let's
Right.
let's not let these people languish in prison without some evaluation at some point. Jail.
Yeah, I mean, defense counsel may occasionally even want to delay for,
More
you know,
time, yeah.
yeah, sometimes, right. But having some kind of benchmark, I think it also helps. Professionalize may not be the right word, but it just sort of sets expectations and might help with, getting funding for additional evaluators and things like that as well.
And don't we have, deadlines already in terms of, 60 days in a felony case for trial, 45 days or maybe it's 30 in misdemeanors if you're in custody. I mean, there's stuff like that.
Definitely.
Yeah.
Yeah, but once a doubt's declared, those,
Those things don't apply, but
Right.
Right, those are speedy trial deadlines. I think the only deadline for competency is within 90 days after you're sent somewhere for treatment. The medical director gives a report to the court.
mhm.
But there's
Well-
nothing sort of in the leading up to the commitment of any timeline.
Yeah.
isn't there a timeline on felonies for transportation to state hospital?
No, what there is there's a 15-day timeline for once you've been declared incompetent for ConRep, for sort of the community, the representative to give a recommendation to the court within 15 court days, I believe, for inpatient or outpatient.
But DSH isn't under a timeline for transportation.
It will
They
be.
are- Yeah, it's a staggered order from the Stiavetti litigation.
Okay. Because that's a mess in LA. I mean, just a disaster.
Yeah.
Okay.
All right. Well, we can we'll add some additional material on sort of, remedy if you violate it or how an extension should work. I think that all makes sense. Natural fit. Okay, so those are the three competency related ideas. The last one is our frequent utilizer idea. So, just to jog everyone's memory, one of the witnesses at the May meeting was Judge Leifman from Miami in Florida, who is, Mr. Mental Health Judge. Thank goodness we were able to have him speak to us. And he just spoke about research they had done showing, it's a small percentage of people using a hugely disproportionate share of resources. There's studies like that all around the country and in California, but they're all a little, they're not every county's doing it, and every place that does it does a little bit differently, which makes sense because everybody, has different needs. And the thing that was a little bit harder to find were examples of, localities that use that linked data once they sort of, linked all its pieces together to actually, change their policies to do things with it. But there are some great examples. I think the one that really stuck out to me the most was San Diego, took a housing first approach to the top, 30 people in their system, and they were able to reduce hospitalization, jail usage, and some of these other things by something like 80%. So huge, return on that investment. But then the program ended because they just weren't able to continue funding for it. So the idea here is that the state should, give money to do this, basically, to link the data, clean it up, make it speak to each other, identify however that locality wants to define what their frequent utilizers are, but identify those folks. That's step one. And then step two is to actually figure out what you're going to do with this data to, better address these folks. So we're not spending good money after bad, as is often the case, and not getting outcomes that are good. So that's the idea is, you fund the data, then you fund the use of the data to make programs with.
And this is for people who exhibited mental illness, substance use disorders, health problems, et cetera. We're not talking about hardcore criminals.
Well, I think those categories are where most counties start because, you
Yeah.
know, those are sort of if you have somebody going to the hospital and the jail, you're going to generate a lot of data about them. But I think really it'd be up to whatever the locality wants to do. They can be up to them where they want to start because there's so many different possibilities.
But the entry point is they're arrested and they're in county jail, or is that it? Or it doesn't matter.
I don't think it necessarily matters. I think it's going to end up being that for almost everybody because, you know, that's just a natural place to try to have an intervention here.
Right. And we are a penal code revision committee.
That's true.
Yeah.
Right. This is a little different than some of our other recommendations for sure, but
because I remember a similar study, professor at Berkeley who, you know, they came up with very similar statistics, but they're all about hardcore, you know, criminal violators committing a disproportionate percentage of the crimes out there. But this is from a mental health, perspective, I think.
I think that's where it will end up for sure.
Yeah.
All right. Well, then I think we're good. So we'll add to these and expand them a little bit as we've talked about, and you'll next see them, I don't know, in November maybe. So that's what we got. Thank you.
All right. Thank you.
Thank you all, especially Joy. Thanks for putting that all together. And you know, as we continue to refine these ideas, I think that this is, you know, obviously an important area and that we can make a big contribution. Unfortunately, it's complicated and not a lot of people know about it or understand it, which I actually think that this is actually where we as a committee can be most helpful. All right, we've come to the point of public comment. To get in line and to comment, please select the raise hand function in Zoom. If you're calling in, you can hit *9. Please note, as always, that this meeting is being held and recorded, and that if you make public comment, your name and phone number may be displayed as part of the recording. I'm going to take a 5-minute break for everybody. And during that break, please log in. Please raise your hand or get in line. Then as when we come back, we'll cut off the line. And depending on how many people in line, we'll see how much time commenters have. So thank you all. I'll see you back in 5 minutes at 3:22. Thanks. All right, if everybody could come back, that'd be appreciated. All right, Tom, how many people have signed up?
4.
Okay, let's
Well,
give up. Go
Oh,
ahead.
I have something we can filibuster with. So I looked into the credit situation, and not only do you get credit, good conduct credit in state hospital, it was done in SB 317, as I think I mentioned, and it was a recommendation of this committee that be done, that passed into law. So I'll go back and edit the video and make us look better. But I can confirm you do get the credit, and we can take some small credit, and pun intended, that ball rolling down the hill.
All right, so 4 people have signed up.
Now it is 7. So
I said I was gonna cut it off after we came back from our break. Okay, 7 people. Let's do 90 seconds, which is our usual amount of time. Can you admit people, or how does, I forget how we do that.
first up, we have Crispy.
Hi, Crispy.
I gotta give her. Here we go. We're ready for you, Crispy.
You're on mute, Crispy.
Sorry about that.
No.
Hi, I'm going to be speaking on behalf of 2 people who are currently incarcerated, and also reminding the committee that 255 people inside California state prisons have died from COVID. The first person I'm speaking on behalf of, and I indulge you to give me like 3 minutes to do all of this, if you can. So from Dortel Williams, he's at Chickasaw Valley State Prison. He's serving life without the possibility of parole. And I personally want to uplift the committee's recommendation to allow an opportunity for people serving the LWOP sentence to have a second look after 25 years. And hopefully, I hope somebody will take that up in this legislative cycle that's coming up. So from Dortel, in regard to sentencing inequalities or extreme sentences, it should be noted that the initial injustices begin with first contact. Over the years, we have seen reports of law enforcement labeling citizens gang members, planting evidence, and using racial slurs over police radios. We need more transparency and accountability. Now, this is from Jasper Stallings, who's serving time at Valley State Prison. When they know you're not wealthy enough to bail out or afford a lawyer, they treat you like you're super guilty right off the bus. That is, mostly us minorities. We are provided the most basic of the basic of legal counsel. Mainly, they push deal, deal, deal on us right out the gate. So if proper representation was provided from the start, not biased or prejudiced, I believe the criminal justice system would have less convictions and more treatment center members that are receiving proper mental health treatment, proper substance abuse treatment, and therapy. So ask, what is the any American citizen who's being charged with a crime? Does the system provide their own people with basic human rights, or does the cycle continue to keep the poor and undereducated locked up in cages? These are our people. Why not provide us with real help, real rehabilitation, real civil service? The next generation will abolish the system. Let's begin the health and healing process now. What's stopping us from being civil? We can start today. And then this is just from me. Hi, I'm Crispy, survivor of harm. First contact with the legal system and law enforcement should include a discussion of the school to prison pipeline. Regarding first contact with law enforcement and trafficking enforcement, when I was a little girl in New York, driving home from upstate New York to Brooklyn, my dad was pulled over for registration, and the police slammed him on top of the hood of the car and arrested him without cause. When you think of the harm done by over-policing and police violence, please think of the generational harm that's done. The trauma and PTSD I experienced through this and other encounters with the police are still with me. So eliminate pretext stops, no car searches without a warrant. Bail advocates sounds like a great idea, and I would like to see a pilot program here in California, as well as no cash bail, as in DC. DDAs should be required to spend time as defense attorneys, preferably public defenders or alternate public defenders, whom are really limited on time spent with defendants, so that they can understand the issues and create a more efficient and just system and process. And there should be salary and resource equity among public defenders and DDAs. I agree on transparency with data shared with community-based organizations, as well as the family members and loved ones. And I want to uplift the need for representation of system impacted people on this committee. I thank you for all your hard work, and I appreciate you all.
Thank you, Crispy. It's Always good to hear your voice. I just want to say something in particular about that. I appreciate your uplifting folks who are inside to this committee. I hope that you return, tell them that we really do appreciate their voice. When at the outset of this committee, we had hoped to be able to conduct hearings inside actual facility. For reasons including COVID, that's proved impossible. But maybe there's a way that we can do some video link or get on CCTV inside. Something that I think is important. So thank you for helping with that.
Next up is Marion Wickard.
Good afternoon, everyone. It's Nervous Marion Wickard here. I wanted to jump in and speak on how LA County works with regard to attorney appointments as arraignment. All clients are appointed either the PD, APD's office, or a bar panel attorney at their arraignment, unless, of course, they've hired a private attorney. The PD and APD office cannot represent everyone due to conflicts. So this is something you need to think of while trying to help those in counties that do not have any of these attorneys' offices. I had a lot more to say on this matter. However, I would like to mention the 26.2 to Life, the San Quentin Prison Marathon documentary, which covers rehabilitation, remorse, redemption, mental health wellness through running, and the Friendly Sign documentaries, which are being released to the general public soon. I don't have the date yet, but coming to you soon. This would allow, I believe each of you on the panel would benefit from watching the documentaries. This would allow all of you to see how valuable your work is. By the way, every man who has participated in the San Quentin 1,000 Mile Club has been released and is still out and has not returned to prison. Not one has returned. Most of these men are lifers or have long determinate sentences like, well, you know, my husband, Tommy Lee Wickard, and his outrageous sentence due to enhancements. Thanks again for everything. Your committee is truly making a difference, and you should have Zoom meetings or something inside with the guys. I agree. Thank you very much for your time.
Thank you, Marion. Appreciate, again, longtime caller, a longtime listener. We appreciate your comments, and please, again, send word that we do hope to find a way to transmit into the facilities.
Thank you.
Next up, Yolanda M.
Hello, thank you, Chair and members. I'm Yolanda Navarrete. I am a crime survivor. I am also system impacted. My husband is serving an LWAP sentence of 28 years, costing the state $2.7 million. First thing, I really appreciate the transparency part. I really feel that dash cams should be transcribed for transparency, and it should be included in the court file. I personally don't believe a policeman should be putting the penal codes down when they're there taking one side of the story and not all the information and the facts and the truth has been told by both sides. Therefore, the penal code should not be given until after all the facts are transcribed for the courts. I also would like to say, I agree with Crispy. Let's alternate the prosecutor like 2 to 4 years in their position, and then they jump back to public defender. I think we'd have more of a just system that way. Also, Placer County Citizens Academy, District Attorney Citizens Academy, I learned that Placer County has a wraparound services for their homeless and mental health patients. They've already got something going. And then last but not least, of course, I would like to ask for a blanket commutation of all LWAPs so they can go to board after 25 years. I think that would give many, many men hope and incentivize those who are not programming to start programming. Thank you very much for your time. Judge Henderson, you're in my prayers constantly. I just want you to know. Thank you very much and have a great day.
Thank you, Yolanda. You mentioned a couple things that I just want to touch on real quick. First of all, the idea that the prosecutors have training in public defender offices is something that I've been very interested in for a while. I believe that the JAG Corps, the military justice system, has some provision along those lines. And the other thing I want to say about blanket commutations is, of course, there's a problem or a complication in the state constitution. The people of more than one felony conviction cannot receive a commutation without approval from the California Supreme Court. So that makes those type of blanket commutations quite burdensome, as we discussed in our death penalty report. But thank you.
We can send them to en banc. We can send them to en banc.
We'll look into that.
All right, next up is Gabriela.
Hi, thank you. As I've mentioned before, anybody's welcome to call me G instead of my mouthful of a name.
I
Appreciate,
knew that.
yeah, appreciate all of you and the work today and the work you do every day. Appreciate you so very much, especially your call to end the death penalty. I did want to, and also thank you so much for supporting AB 256. Hopefully the governor will sign that bill. I'm really disheartened, and so I just wanted to lift up, obviously I'm really sad that SB 300 had to be shelved. And also I wanted to mention the Vision Act AB 937. If any of you are in communication with the governor, other legislators, and or any way to cover this aspect of the work you do. Transferring folks from CDCR to ICE and then deporting people who have maybe never even been to their country of origin or left as children. It's just the most abysmal thing that we can do as Californians. I want to uplift Punyu, who recently got deported to Cambodia. His parents are in wheelchairs, they're in their 90s, they may never see him again. And he was a model person utilizing restorative justice and learning from his experience and giving it to him in our community. We need him here in California on so many levels. So I think I may have used my minute and a half, but yeah, and I don't know how that would, what shape that might take place at this within your group, but I do hope you can lift that up.
Thank you, G. It's good to hear your voice too. I should say that one of my very first clients was in exactly that situation where he was released from a 3-strike sentence and then faced deportation to Iran, where he had never really been since he was like 6 years old. So that's a very important, tricky issue, and I appreciate your support for that.
Thank you.
All right, next is Pat Espinoza.
Hi, can you hear me?
Yes.
Great. I just wanted to follow up on a comment that Chairman Romano made with respect to if took longer than 30 days for the competency reports to be done, and this is suggestion a possible remedy could be dismissal. And there was the comment that the DA could refile the case, and that the concern is that the prosecutors don't have an endless supply of the ability to refile a case. And when you are talking about violent offenders, charged with murder and attempted murder that we see, the concept that because someone in the mental health system, because of staffing, because of caseloads, cannot complete their report in time, the idea that they should receive the benefit of a dismissal of a criminal action of a violent felony like that, I mean, that's a serious threat to public safety. And we just wanted to raise that. I'm sure you're aware of that, but I mean, we would hope that that is just a thought and not a serious policy recommendation, that the recommendation should be dismissal of a violent criminal action like murder, attempt murder, when it's out of the hands of the police or the prosecution, how long the mental health evaluator takes to complete a competency report. So that's my concern, and would love to hear your comments. Thanks.
So very briefly, we were just brainstorming solutions. On the one hand, I feel that there should be systemic pressure on the various actors in order to accomplish these mental health reports expeditiously and without having any oversight or teeth in a recommendation, I think is problematic. As you probably heard also from our conversation, though, that I think that the committee quickly gravitated towards a way where prosecutors could go to court and ask for extensions for that timeline for a good cause. And endangering public safety would probably be principal among those causes. So, as if you've been following the committee for any period of time, I think that that we have that the best reforms that we can come up with both improve outcomes, both for defendants, but also for public safety. That's really what we're looking for. We certainly aren't intending and will never intentionally recommend something that to interfere with public safety. But I understand your concern.
Thank you.
All right, next is Raina Selnick.
Hello, can you hear me?
Yes.
Okay, hi, I'm Raina Selnick. I just briefly wanted to say, I had other plans to say other things, and then I was really struck by this idea of the people moving between the public defender and the prosecutor's office. And
Yes.
I'd just like to say, I really think that's an interesting idea worth exploring. Particularly for the prosecutor's office, I think it would have to be done really intentionally. I've had my loved one is currently serving life without parole, and his case has been conflicted off from the public defender's office a lot. And I'm also worked as a mitigation specialist with a lot of attorneys who were former prosecutors. And I am concerned about their ability to serve as defense attorneys. So I think, yeah, there would have to be a lot of training, but I think it's a really interesting idea to explore. Thank you.
Thank you. As I said, it's been a long interest of mine. In fact, I wrote a law school paper about it. But perhaps something for us to look into. And I do think if you're interested in it, and if I am, and so to look into how the JAG system works in the military, because I do think that there is some requirement. And then there are, of course, concerns about zealous advocacy of criminal defendants by folks who end up wanting to be prosecutors. That could be problematic. But I do think it's a really interesting way to think about things.
That's it.
Oh, all right. Thank you all. It's been another long day. We're about to start a long weekend. Thanks especially to staff. Congratulations to Rick for all of his expanding family. Have a good weekend. I will see you all. For members of the committee, obviously, please be in touch with me and or Tom if you have specific questions that you want to follow up on or ideas for us for further consideration. We really appreciate it. I will be in touch with Assemblymember Lee and Senator Skinner to fill them on what they missed. And have a good weekend, everybody. Goodbye. Thank you so much.
And to you.
right.
Bye-bye.